Right now, inside the building where you just fell, a hard drive is running a countdown, not your recovery countdown. The countdown to the permanent deletion of the only footage that can prove exactly what happened to you. Most commercial surveillance systems in the United States automatically overwrite recorded footage every 48 to 72 hours. That retention window was not set by an IT engineer trying to manage storage space. It was written by a corporate legal team trying to manage slip and fall lawsuit exposure. By the time most injured people see a doctor, understand the full extent of their injuries, and consider calling an attorney, the surveillance footage of their fall is already gone. But the surveillance footage is only the first piece of evidence that disappears. There are 3 others, and all 4 begin erasing themselves the exact moment your body hits that floor. Welcome to Torts and Truth. This is your decoded advocate. If this episode delivers value, like, share, and subscribe, and drop your experience in the comments below. Every slip and fall case in the United States is built on a single foundation. Not pain, not medical bills, not the severity of your injuries, evidence, and in a slip and fall claim. The most critical evidence in your favor is controlled, maintained, and in some cases deliberately eliminated by the exact party responsible for your injuries. There are 4 categories of evidence that begin disappearing within the first 24 hours of any premises liability incident. Understanding each one and acting on each one is the difference between a full settlement and a dismissed claim. Evidence Category 1. Surveillance footage. A 30-second clip showing a wet floor with no warning sign is worth more than any expert witness, any medical opinion, or any legal argument your attorney can make in a courtroom. It is direct, it is irrefutable, and it is the most devastating piece of evidence that can exist in a premises liability case. It also has an expiration date. Major commercial properties, grocery chains, retail stores, restaurants, hotels, and shopping facilities operate their recording systems under an internal framework their legal departments refer to as a loop recording protocol. Under this protocol, footage is automatically overwritten once the storage system reaches a designated capacity threshold. In documented premises liability cases on record, the standard retention window at major commercial facilities is 48 to 72 hours. That window was not established by a technician solving a storage problem. It was established by an attorney solving a litigation problem. A shorter retention cycle means fewer available recordings for injured plaintiffs. Fewer recordings mean fewer viable slip and fall lawsuits reaching settlement. Fewer lawsuits mean lower annual claims exposure for the insurance carrier. The camera positioned directly above the spot where you fell was operating under a policy that was specifically designed to work against you before you ever needed it. The surveillance system that captured your fall was engineered by the same legal team that will defend against your lawsuit. Evidence Category 2. Floor inspection logs. Every regulated commercial property in the United States is required to maintain floor inspection logs under internal safety protocols aligned with Occupational Safety and Health Administration standards. These logs document when each floor zone was last inspected, who performed that inspection, what hazardous conditions were identified, and what corrective action was taken. Under premises liability law in most U.S. states, a property owner must establish either actual notice or constructive notice of a hazardous condition to be held legally liable. Constructive notice means the dangerous condition existed long enough that a reasonable property owner should have discovered and corrected it. Floor inspection logs are the primary document through which courts evaluate that legal standard. After a customer falls, those logs do not remain in a neutral archive. They are reviewed by management before any attorney ever sees them. In multiple documented civil cases on record, inspection logs showed floor checks completed just minutes before an incident. Entries that forensic document analysis later identified as backdated. In multiple documented civil cases on record, inspection logs showed floor checks completed just minutes before an incident. Entries that forensic document analysis later identified as backdated. Under Federal Rules of Civil Procedure Rule 26, the legal duty to preserve relevant evidence attaches the moment litigation is reasonably anticipated. That moment is not when you hire an attorney. That moment is not when you file a lawsuit. That moment is your fall. If a store alters, destroys, or manufactures inspection records after that moment, that is spoliation of evidence. And spoliation is not a procedural technicality. It is a legal catastrophe for the defendant. The moment you hit that floor, a federal preservation obligation attached to every document in that building, whether the property owner honored it or not. Evidence Category 3. The incident report. Filing an incident report at the scene feels like the responsible protective action to take. It is the single most strategically misunderstood step in any slip and fall claim. When you submit an incident report to store personnel, you are not creating a record that works in your favor. You are creating a document that their risk management department will own, control, and deploy strategically against you. In most states, you carry no statutory right to leave that property with a copy. That report transfers directly to the insurance carrier's claims department, often within hours of the incident. Carriers use early incident reports for one precise strategic purpose: to establish a baseline account of your injuries before you have medical imaging, legal representation, or a complete understanding of your own physical condition. Here is exactly how this plays out in practice. You characterize your pain as moderate at the scene. You go home. 3 weeks later, your MRI reveals a herniated disc at 2 spinal levels. The carrier retrieves your incident report, where you described moderate pain, and uses that single document to systematically challenge the severity and credibility of your entire injury claim. Inside insurance claims departments, this tactical process has a name. It is called early statement capture. It is not customer care. It is not documentation protocol. It is pre-litigation evidence collection, executed against you before you ever speak to an attorney. The 4 actions you take in the first 24 hours. Action 1. Document the scene before you leave. Use your phone. Photograph the floor, the absence of any warning sign, the lighting conditions, your visible injuries, your clothing, the exact location of the fall. Action 2. Collect witness contact information before anyone leaves the premises. Name and phone number. 2 pieces of information that can define the outcome of your entire slip and fall claim. Action 3. File the incident report and control every word precisely. Confirm the incident occurred. Provide your identity and contact information. Do not characterize your pain level. Do not say you feel fine. Do not minimize what happened in any way. Action 4. Contact a personal injury attorney within 24 hours, not next week, not after you assess how the injury develops. The spoliation letter must be transmitted within 24 to 48 hours to carry maximum legal force. Every hour you wait is another hour that surveillance countdown is running. If you do not want insurance adjusters and risk management teams controlling your evidence timeline before you understand your own legal rights, subscribe, because the next episode exposes exactly how carriers use your medical treatment timeline to reduce your settlement before your attorney ever receives the first offer. Tell me in the comments, did your attorney send a spoliation letter after your incident? Or was critical evidence already gone before legal help arrived? I want to hear what happened. If you missed our last video on how insurance companies use independent medical examinations to undermine your injury claim, the link is in the description below. Watch it after this one. This is your Decoded Advocate, and I will see you in the next one.